It's May 30, 2022. Still reading Verba, Juris, Bar Review Notes, Labor Law and Social Legislation, Volume 1. Labor Relations, Right to Self-Organization. The right to self-organization is not limited to unionism. Workers may also form or join an association for mutual aid and protection and for other legitimate purposes. Who may or may not exercise the right? Right to self-organization includes right to form a union, workers' association, and labor management council. More often than not, the right to self-organization connotes unionism. Workers, however, can also form and join a workers' association as well as labor management councils. Expressed in the highest law of the land is the right of all workers to self-organization. Section 3, Article 13 of the 1987 Constitution states, Section 3, the state shall afford full protection to labor, local and overseas, organized and unorganized, and promote full employment and equality of employment opportunities for all. It shall guarantee the rights of all workers to self-organization, collective bargaining and negotiations, and peaceful concerted activities, including the rights to strike in accordance with law. And Section 8, Article 3 of the 1987 Constitution also states, Section 8, the right of the people, including those employed in the public and private sectors, to form unions, associations, or societies for purposes not contrary to law shall not be abridged. In relation thereto, Article 3 of the 1987 Constitution, Article 3 pala of the Labor Code provides Article 3, Declaration of Basic Policy, the state shall afford full protection to labor, promote full employment, ensure equal work opportunities regardless of sex, race, or creed, and regulate the relations between workers and employers. The state shall assure the rights of workers to self-organization, collective bargaining, security of tenure, and just humane conditions of work. Substitutionary doctrine. The substitutionary doctrine provides that the employees cannot revoke the validly executed a collective bargaining contract when their employer, by the simple expedient of changing their bargaining agent, the new agent must respect the contract. The employees, through their new bargaining agent, cannot renege on the collective bargaining contract except to negotiate with management for the shortening hereof. Substitutionary doctrine cannot be invoked to support the claim that a newly certified collective bargaining agent automatically assumes all personal undertakings, such as the non-strike stipulation in this case, assumed by the deposed union and the BBWU bound itself and its workers not to strike, could not bind all the rival unions because the BBWU was the agent only of the employees, not of the other unions which possess distinct personalities. The substitutionary doctrine only provides that the employees cannot revoke the validly executed collective bargaining contract with their employer by the simple expedient of changing their bargaining agent, and it is in the light of this that the phrase said new agent would have to respect said contract must be understood. Only means that the employees, through their new bargaining agent, cannot renege on their collective bargaining contract, except of course to negotiate with the management for the shortening hereof. The justification for this doctrine is that the majority of the employees as an entity under the statute is the true party in interest to a labor agreement, holding rights through the mere agency of their union representative. Thus, any exclusive interest claimed by the agent is defeasible at the will of the principal. Bargaining unit. A bargaining unit has been defined as a group of employees of a given employer, comprised of all or less than all of the entire body of employees, which the collective interests of all the employees consistent with equity to the employer indicated to be the best suited to serve reciprocal rights and duties of the parties under the collective bargaining provisions of the law. In view of the revered right of every worker to self-organization, the law expressly allows and even encourages The formation of labor organizations. A labor organization is defined as any union or association of employees which exists in whole or in part for the purpose of collective bargaining or of dealing with employers concerning terms and conditions of employment. A labor organization has two broad rights. First, to bargain collectively, and second, to deal with the employer concerning terms and conditions of employment. To bargain collectively is a right given to a union once it registers itself with the DOLE. Dealing with the employer, on the other hand, is a generic description of interaction between employer and employees concerning grievances, wages, work hours, and other terms and conditions of employment, even if the employees group is not registered with the DOLE. Bargaining representative. Collective bargaining is just one of the forms of employee participation. Despite so much interest in and the promotion of collective bargaining, it is incorrect to say that it is the device and no other which secures industrial democracy. It is equally misleading to say that the collective bargaining is the end goal of employee representation. Rather, the real aim is employee participation in whatever form it may appear, bargaining or no bargaining, union or no union. Any labor organization which may or may not be a union may deal with the employer. This explains why a workers' association or organization does not always have to be a labor union, and why employer-employee collective interactions are not always collective bargaining. Determination of representation status, registry of unions, and file of collective agreements. The Bureau shall keep a registry of legitimate labor organizations. The Bureau shall also maintain a file of all collective bargaining agreements and other related agreements and records of settlement of the labor disputes and copies of orders and decisions of voluntary arbitrators or panel of voluntary arbitrators. The file shall be open and accessible to interested parties under conditions prescribed by the Secretary of Labor and Employment, provided that no specific information submitted in confidence shall be disclosed unless authorized by the Secretary, or when it is an issue in any judicial litigation, or when public interest or national security so requires. Representation issue in organized establishments. In organized establishments, when a verified petition questioning the majority status of the incumbent bargaining agent is filed before the Department of Labor and Employment within the 60-day period before the expiration of a collective bargaining agreement, the Med Arbiter shall automatically order an election by secret ballot when the verified petition is supported by the written consent if at least 25% of all the employees in the bargaining unit to ascertain the will of the employees in the appropriating bargaining unit. To have a valid election, at least a majority of all eligible voters in the unit must have cast their votes. The labor union receiving the majority of the valid votes cast shall be certified as the exclusive bargaining agent of all the workers in the unit. When an election which provides for 3 or more choices results in no choice receiving a majority of the valid votes cast, a runoff election shall be conducted between the labor unions receiving the 2 highest number of votes, provided that the total number of votes for all contending unions is at least 50% of the number of votes cast. At the expiration of the freedom period, the employer shall continue to recognize the majority status of the incumbent bargaining agent where no petition for such certification election is filed. Rights of labor organizations. In the case at bench, the court cannot sanction the opinion of the CA that Samahan should have formed a union for purposes of collective bargaining instead of a workers' association because the choice belonged to it. The right to form or join a labor organization necessarily includes the right to refuse or refrain from exercising the said right. It is self-evident that just as no one should be denied the exercise of a right granted by law, so also no one should be compelled to exercise such a conferred right. Also inherent in the right to self-organization is the right to choose whether to form a union for purposes of collective bargaining or a workers' association for purposes of providing mutual aid or protection. Check of assessment agency fees. All unions are authorized to collect reasonable membership fees, union dues, assessments and fines, and other contributions for labor education and research, mutual debt and hospitalization benefits, welfare fund, strike fund, and credit and cooperative undertakings. Collective bargaining. Duty to bargain collectively, a cursory reading of the law demonstrates that a common element between unionism and the formation of LMCs is the existence of an employer-employer relationship where neither party is an employer nor an employee of the other. No duty to bargain collectively would exist. In the same manner expressed in Article the requirement that such typographical error. The requirement that such workers be employed in the establishment before they can participate in policy and decision-making processes. Procedure in collective bargaining. The following procedures should be observed in collective bargaining. When a party desires to negotiate an agreement, it shall serve a written notice upon the other party with a statement of its proposals. The other party shall make a reply thereto not later than 10 calendar days for receipt of such notice. B. Should differences arise on the basis of such notice or reply, either party may request for a conference which shall begin not later than 10 calendar days from the date of request. C. If the dispute is not settled, the board shall intervene upon request of either or both parties or at its own initiative and immediately call the parties to conciliation meetings. The board shall have the power to issue subpoenas requiring the attendance of the parties to such meetings. It shall be the duty of the parties to participate fully and promptly in the conciliation meetings the board may call. During the conciliation proceedings in the board, the parties are prohibited from doing any act which may disrupt or impede the early settlement of the disputes. And E. The board shall exert all efforts to settle disputes amicably, encourage the parties to submit their case to a voluntary arbitrator. Collective bargaining. Collective bargaining agreement. Collective bargaining agreement as used in the labor code is a contract executed as the request of either the employer or employee's exclusive bargaining representative with respect to wages as used in the labor code is a contract executed as a request of either the employer or employee's exclusive bargaining representative with respect to wages, hours of work, and all other terms and conditions of employment, including proposals for adjusting any grievances or questions under such agreement. A collective bargaining agreement or CBA refers to the negotiated contract between a legitimate labor organization and the employer concerning wages, hours of work, and all other terms and conditions of employment and bargaining unit. Generally, the collective bargaining agreement controls the relationship between the parties. Any benefit not included in it is not demandable. Mandatory provisions in a collective bargaining agreement. Article 253A, Terms of a collective bargaining agreement. Any collective bargaining agreement that the parties may enter into shall, insofar as the representation aspect is concerned, be for a term of 5 years. No petition questioning the majority status of the incumbent bargaining agent shall be entertained, and no certification election shall be conducted by the Department of Labor and Employment outside of the 60-day period immediately before the date of expiry of such 5-year term of the collective bargaining agreement. All other provisions of the collective bargaining agreement shall be renegotiated not later than 3 years after its execution. Any agreement on such other provisions of the collective bargaining agreement entered into within 6 months from the date of expiry of the term of such other provisions as fixed in the collective bargaining agreement shall retroact to the day immediately following such date. If any such agreement is entered into beyond 6 months, the parties shall agree on the duration of retroactivity thereof. In case of a deadlock in the renegotiation of the collective bargaining agreement, the parties may exercise their rights under this code. Unfair labor practices, ULP. Nature aspects. Unfair labor practice refers to acts that violate the workers' rights to organize. It is an unfair labor practice for a labor organization to cause or attempt to cause an employer to discriminate against an employee, including discrimination against an employee with respect to whom membership in such organization has been denied, or to terminate an employee on any ground other than the usual terms and conditions under which membership or continuation of membership is made available to other members. Peaceful concerted activities. A labor dispute includes any controversy or matter concerning terms or conditions of employment, or the association or representation of persons in negotiating, fixing, maintaining, changing, or arranging the terms and conditions of employment, regardless of whether the disputants stand in the proximate relation of employer and employee. Strike. Valid strikes, as distinguished from illegal strikes. Procedurally, for a strike to be valid, it must comply with Article 278 of the Labor Code. A strike is the most powerful of the economic weapons of workers which they unsheath to force management to agree to an equitable sharing of the joint product of labor and capital. It is a weapon that can either breathe life to or destroy the union and its members in their struggle with management for a more equitable due to their labors. The decision to declare a strike must therefore rest on a rational basis, free from emotionalism envisaged by the tempers and tantrums of a few hotheads, and finally focus on the legitimate interests of the union, which should not, however, be antithetical to the public welfare. And to be valid, a strike must be pursued within legal bounds. The right to strike as a means of attainment of social justice is never meant to oppress or destroy the employer. Since strikes cause disparity, affects not only on the relationship between labor and management, but also on the general peace and progress of society. The law has provided limitations on the right to strike. For a strike to be valid, the following procedural requisites provided by Article 263 of the Labor Code must be observed. A notice of strike filed with the DOLE 30 days before the intended date thereof, or 15 days in case of unfair labor practice. And B, strike vote approved by majority of the total union membership, and the bargaining unit concerned obtained a secret ballot in a meeting called for that purpose. C, notice given to the DOLE of the results of the voting at least 7 days before the intended strike. These requirements are mandatory, and the failure of a union to comply therewith renders the strike illegal. It is clear in this case that petitioners totally ignored the statutory requirements and embarked on their illegal strike. In the determination of the consequences of illegal strikes, the law makes a distinction between union members and union officers. Fairness and justice dictate that back wages be denied the employees who participated in the illegal concerted activities to the great detriment of the employer. Picketing involves merely the marching to and fro of the premises of the employer, usually accompanied by the display of placards and other signs making known the facts involved in a labor dispute. As applied to a labor dispute, to picket means the stationing of one or more persons to observe and attempt to observe. The purpose of pickets is said to be a means of peaceable persuasion. Even a cursory reading of the agreement of the parties already show that they did not thereby intend to write finis or put an end to the cases filed against each other in the Department of Labor and Employment and the NLRC. They merely agreed to maintain their status quo before the commencement of the complaints filed by them, without prejudice to the resolution by the labor arbiter of the factual and legal issues raised after the presentation of their respective evidence. The parties merely agreed that the respondent would stop its strike against the petitioner and lift its picket within the latter's premises, and that the petitioner, in turn, would allow the members of the respondent union to return back to work to enable the petitioner to resume its business operations. The parties did not intend to put an end to the cases pending against each other. In point of fact, after the execution of the said agreement, the parties adduced their respective testimonial and documentary evidences on the factual and legal issues, instead of asking the labor arbiter and the DOLE to dismiss the complaints filed by the parties against each other. The parties' presentation of their respective evidence after the execution of their compromise agreement is conclusive proof that the said agreement is not compromise agreement envisaged in Article 2028 of the new Civil Code. The contemporaneous and subsequent acts of the parties belie the ruling of the Court of Appeals that the petitioner waived its right to assail the illegality of the strike. The act of workers in failing to heed the order of their superior from joining the picket is only tantamount to insubordination, which cannot be considered as an illegal or unlawful act committed during the strike to justify their dismissal from employment by employer. Lockout. When in his opinion there exists a labor dispute causing or likely to cause a strike or lockout in an industry indispensable to the national interest, the Secretary of Labor and Employment may assume jurisdiction over the dispute and decide it or certify the same to the Commission for compulsory arbitration. Such assumption or recertification shall have the effect of automatically enjoining the intended and or impending strike or lockout as specified in the assumption or certification order. If one has already taken place at the time of assumption or certification, all striking or locked out employees shall immediately return to work, and the employer shall immediately resume operations and readmit all workers under the same terms and conditions prevailing before the strike or lockout. The Secretary of Labor and Employment or the Commission may seek the assistance of law enforcement agencies to ensure compliance with this provision, as well as with such orders as he may issue to enforce the same. Assumption of jurisdiction by Secretary of Labor and Employment. In line with the national concern for and the highest aspect accorded to the right of patients to life and health, strikes and lockouts in hospitals, clinics, and similar medical institutions shall to every extent possible be avoided, and all serious efforts, not only by labor and management but government as well, be exhausted to substantially minimize, if not prevent, their adverse effects on such life and health, through the exercise, however legitimate, by labor of its right to strike and by management to lock out in labor disputes adversely affecting the continued operation of such hospitals, clinics, or medical institutions. It shall be the duty of the striking union or locking out employer to provide and maintain an effective skeletal workforce of medical and other health personnel whose movement and services shall be unhampered and unrestricted as are necessary to ensure the proper and adequate protection of the life and health of its patients, most especially emergency cases for the duration of the strike or lockout. In such cases, therefore, the Secretary of Labor and Employment may immediately assume within 24 hours from knowledge of the concurrence of such a strike or lockout jurisdiction over the same or certify it to the Commission for compulsory arbitration. For this purpose, the contending parties are strictly enjoined to comply with such orders, prohibitions, and injunctions as are issued by the Secretary of Labor and Employment or the Commission under pain of immediate disciplinary action, including dismissal or loss of employment status or payment by the locking out employer of back wages, damages, and other affirmative relief, even criminal prosecution against either or both of them. Industry indispensable to the national interest. The foregoing notwithstanding, The President of the Philippines shall not be precluded from determining the industries that, in his opinion, are indispensable to the national interest and from intervening at any time in assuming jurisdiction over any labor dispute in such industries in order to settle or terminate the same. Effects of assumption of jurisdiction. The Secretary of Labor and Employment, the Commission, or the Voluntary Arbitrator or panel of voluntary arbitrators shall decide or resolve the dispute within 30 calendar days from the date of the assumption of jurisdiction or the certification or submission of the dispute, as the case may be. The decision of the President, the Secretary of Labor and Employment, the Commission, or the Voluntary Arbitrator or panel of voluntary arbitrators shall be final and executory 10 calendar days after receipt thereof by the parties. Management prerogative, discipline. The right of an employer to regulate all aspects of employment applicable management prerogative gives employers the freedom to regulate according to their discretion and best judgment all aspects of employment, including work assignment, working methods, processes to be followed, working regulations, transfer of employees, work supervision, layoff of workers, and the discipline, dismissal, and recall of workers. In the exercise of its management prerogative, an employer must therefore ensure that policies, rules, and regulations on work-related activities of their employees must always be fair and reasonable, and the corresponding penalties, when prescribed, commensurate to the offense involved and to the degree of the infraction. Transfer of employees. Although the respondent's transfer to Manila might be potentially inconvenient for them because it would entail additional expenses on their part, aside from their being forced to be away from their families, it was neither unreasonable nor oppressive. The right of the employee to security of tenure does not give her a vested right to her position as to deprive management of its authority to transfer or reassign her where she will be most useful. While the law imposes many obligations upon the employer, nonetheless it also protects the employer's right to expect from its employees not only good performance, adequate work, and diligence, but also good conduct and loyalty. In fact, the labor code does not excuse employees from complying with valid company conditions they have to endure. An employer, as an exercise of management prerogative, has the right to adopt valid and equitable grounds as a basis for terminating or transferring employees. When the transfer of an employee is not unreasonable or inconvenient or prejudicial to him, and it does not involve a demotion in rank or a diminution of his salaries, benefits, and other privileges, the employee may not complain that it amounts to a constructive dismissal. Productivity standards. The Supreme Court has consistently ruled that the power to dismiss an employee is a recognized prerogative inherent in the employer's right to freely manage and regulate business. The worker's right to security of tenure is not absolute right, for the law provides that he may be dismissed for cause. The Supreme Court has recognized that the employer has the right to regulate according to its discretion and best judgment all aspects of employment, including work assignment, working methods, processes to be followed, working regulations, transfer of employees, working supervision, layoff of workers, and the discipline, dismissal, and recall of workers. Bonus. The grant of bonus or special incentive, being a management prerogative, is not demandable and enforceable obligation except when the bonus or special incentive is made part of the wage, salary, or compensation of the employee, or is promised by the employer and expressly agreed upon by the parties. Change of working hours. But we are more impressed and are persuaded to accept as true the contention of the respondent Marcelo companies that the aforestated requirement was only for purposes of power scheduling of the start of work for each returning strikers. It must be noted that as a consequence of the two strikes which were both attended by widespread acts of violence and vandalism. The businesses of the respondent companies were completely paralyzed. It would hardly be justiciable to demand of the respondent companies to readmit all the returning workers in one big force, or as each demanded a readmission. There were machines that were not in operating condition because of long disuse during the strikes. Some of the machines needed work than one worker to operate them, so that in the absence of the needed team of workers, the start of work by one without his teammates would necessarily be useless, and the company would be paying for his time spent doing no work. Finally, we take judicial cognizance of the fact that companies whose businesses were completely paralyzed by major strikes cannot resume operations at once and in the same state or force as before the strikes. Marriage between employers of competitor employers. And the wordings of the contractual provision and the policy of its employee handbook, it is clear that Glaxo does not impose an absolute prohibition against a relationship between its employees and those of competitor companies. Its employees are free to cultivate relationships with and marry persons of their own choosing. What the company merely seeks to avoid is a conflict of interest between the employee and the company that may arise out of such relationships. That Glaxo possesses the right to protect its economic interests cannot be denied. No less than the Constitution recognizes the right of enterprises to adopt and enforce such a policy to protect its right to reasonable returns on investments and to expansion and growth. Indeed, while our laws endeavor to give life to the constitutional policy on social justice and the protection of labor, it does not mean that every labor dispute will be decided in favor of the workers. The law also recognizes that management has rights which are also entitled to respect and enforcement in the interest of fair play. No reversible error can be ascribed to the Court of Appeals when it ruled that Glaxo's policy prohibiting an employee from having a relationship with an employee of a competitor company is a valid exercise of management prerogative. Glaxo has a right to guard its trade secrets, manufacturing formulas, marketing strategies, and other confidential programs and information from competitors, especially so that it and Astra are rival companies in the highly competitive pharmaceutical industry. Social legislation. Social security system law. This court has been very consistent in characterizing the funds being administered by SSS as a trust fund for the welfare and benefit of workers and employees in the private sector. In United Christian Missionary versus Social Security Commission, we were unequivocal in declaring the funds contributed to the social security system by compulsion of law as funds belonging to the members, which were merely held in trust by the government, and resolutely imposed the duty upon the trustee to desist from any and all acts which would diminish the property rights of owners and beneficiaries of the trust fund. Consistent with this declaration, it would indeed be very reasonable to construe the authority of the SSC to provide for the compensation of SSS personnel in accordance with the established rules governing the remuneration of trustees. The modern rule is to give the trustee a reasonable remuneration for his skill and industry. In deciding what is a reasonable compensation for a trustee, the court will consider the amount of income and capital received and disbursed, the pay customarily given to agents or servants for similar work, the success or failure of the work of the trustee, any unusual skill which the trustee had induced, the amount of risk and responsibility, the time consumed, the character of the work done, whether routine or of unusual difficulty, and any other factors which prove the worth of the trustee's services to the situis. The court has power to make extraordinary compensation allowances, but will not do so unless the trustee can prove that he has performed work beyond the ordinary duties of his office and has engaged in especially arduous work. coverage and exclusions under Section 3A of the SSS law. The appointive members of the SSC may be entitled to a 2,500 pesos per diem for each meeting actually attended, but not to exceed 10,000 pesos per month. 2,500 per diem for members who hear and evaluate cases, but not to exceed 15,000 pesos per month. And rata as fixed by the SSC, but not exceed 10,000 pesos per month. The question now is whether the benefits provided under the said provision are reasonable compensation, so that the grant of additional benefits such as the disallowed disbursements is precluded. Dependents and beneficiaries benefits. Verily, the SSS cannot grant additional benefits to SSC members other than the reasonable allowances specified by the law. To do so would be contrary to the intentions of Congress for the SS law to categorically enumerate the benefits to be received by SSC members. It must be remembered that the objective of the law was to provide reasonable and adequate compensation to SSC members, guided by the recommendations of the SSS Administrator. Congress specifically provided for the benefits to be received by SSC members. Thus, Congress deemed the said amounts to be reasonable compensation to SSC members, as they were the same benefits suggested by the former SSS Administrator. Government Service Insurance System. The funds and assets of Government Service Insurance System may, after the resolution of the appeal and bearing any provisional injunction thereto, be subjected to execution, attachment, garnishment, or levy, since the exemption under Section 39 of the Republic Act number 8291 does not operate to deny private entities from properly enforcing their contractual claims against GSIS. Limited Portability Law. Sickness as defined under Article 167, Chapter 1, Title 2, Book 4 of the Labor Code of the Philippines refers to any illness definitely accepted as an occupational disease listed by the Employees Compensation Commission, or any illness caused by employment, subject to proof that the risk of contracting the same is increased by working conditions. Disability and death benefits. Disability does not refer to the injury or the pain that it is occasioned, but to the loss of impairment of earning capacity. There is disability when there is a diminution of earning power because of actual absence from work. This absence must be due to the injury or illness arising from and in the course of employment. Thus, the basis of compensation is reduction of earning power. Labor Code. There are three kinds of disability benefits under the Labor Code as amended by PD number 626: temporary total disability, permanent total disability, permanent partial disability. Employees' Compensation and Insurance Fund. Permanent partial disability occurs when an employee loses the use of any particular anatomical part of his body, which disables him to continue with his former work. In this case, while petitioner's own company designed physician, Dr. DOLE, certified that respondent was still fit to work, the former admitted in the same breath that respondent's left eye could no longer be improved by medical treatment. As early as April 13, 2002, Dr. DOLE had in fact diagnosed respondent's left eye as permanently disabled, to wit, present ophthalmologic examination showed corneal scar and cystic macula of the left eye. Vision on the right eye is 20/20, and while the left showed 20/60, and our ophthalmologist opined that no more improvement can be attained on the left eye, but patient can return back to duty with left eye disabled by 30%. Petitioner's argument that the injury was curable because respondent underwent cataract extraction in on both eyes in 2003, and Dr. DOLE issued a medical evaluation finding the respondent's best corrected vision for both eyes was 20/20 with correctional glasses, are thus inconsequential. The curability of the injury does not preclude an award for disability because, in labor laws, disability need not render the seafarer absolutely helpless or feeble to be compensable. It is enough that it incapacitates him to perform his customary work. Philippine Overseas Employment Administration Standard Employment Contract. The POEA Standard Employment Contract was designed primarily for the protection and benefit of Filipino seamen in the pursuit of their employment on board ocean-going vessels. In resolving disputes regarding disability benefits, its provisions must be construed and applied fairly, reasonably, and liberally in the seaman's favor, because only then can the provisions be given full effect. Besides, the schedule of disabilities under Section 32 is in no way exclusive. Section 20.B.4 of the same POA Standard Employment Contract clearly provides that those illnesses not listed in Section 32 of this contract are disputably presumed as work-related. This provision only means that the disability schedule also contemplates injuries not explicitly listed under it. Disability should be understood less on its medical significance but more on the loss of earning capacity. Solo parents. The employer shall provide for a flexible working schedule for solo parents, provided that the same shall not affect individual and company productivity. Provided further that any employer may request exemption from the above requirements from the DOLE on certain meritorious grounds. Solo parent. Any individual who falls under any of the following categories: a woman who gives birth as a result of rape and other crimes against chastity, even without a final conviction of the offender, prohibited that the mother keeps and raises the child. Parent left solo or alone with the responsibility of parenthood due to death of spouse. Parent left solo or alone with the responsibility of parenthood while the spouse is detained or is serving sentence for a criminal conviction for at least 1 year. Fourth, parent left solo or alone with the responsibility of parenthood due to physical and or mental incapacity of spouse as certified by a public medical practitioner. Fifth, parent left solo or alone with the responsibility of parenthood due to legal separation or de facto separation from spouse for at least 1 year as long as he or she is entrusted with the custody of the children. Sixth, parent left solo or alone with the responsibility of parenthood due to declaration of nullity or annulment of marriage as decreed by a court or by a church as long as he or she is entrusted with the custody of the children. 7. Parent left solo or alone with the responsibility of parenthood due to abandonment of spouse for at least 1 year. 8. Unmarried mother, father who has preferred to keep and rear his or her children instead of having others care for them or give them up to a welfare institution. 9. Any other person who solely provides parental care and support to a child or children. 10th, any family member who assumes the responsibility of head of family as a result of the death, abandonment, disappearance, or prolonged absence of the parents or solo parent. A change in the status or circumstance of the parent claiming benefits under this act, such that he or she is no longer left alone with the responsibility of parenthood, shall terminate his or her eligibility for these benefits. Kasambahay. Standard of treatment. The employer or any member of the household shall not subject a domestic worker or kasambahay to any kind of abuse nor inflict any form of physical violence or harassment or any act tending to degrade the dignity of a domestic worker. Board, lodging, and medical attendance. The employer shall provide for the basic necessities of the domestic worker to include at least 3 adequate meals a day and humane sleeping arrangements that ensure safety. The employer shall provide appropriate rest and assistance to the domestic worker in case of illness and injuries sustained during service without loss of benefits. At no instance shall the employer withdraw or hold in abeyance the provision of these basic necessities as punishment or disciplinary action to the domestic worker. Guarantee of privacy. Respect for the privacy of the domestic worker shall be guaranteed at all times and shall extend to all forms of communication and personal effects. This guarantee equally recognizes that the domestic worker is obliged to render satisfactory service at all times. Access to outside communication. The employer shall grant the domestic worker access to outside communication during free time, provided that in case of emergency, access to communication shall be granted even during work time. Should the domestic worker make use of the employer's telephone or other communication facilities, the costs shall be borne by the domestic worker unless such charges are waived by the employer. Right to education and training. The employer shall afford the domestic worker the opportunity to finish basic education and may allow access to alternative learning systems and, as far as practicable, higher education or technical and vocational training. The employer shall adjust the work schedule of the domestic worker to allow such access to education or training without hampering the services required by the employer. Prohibition against privileged information. All communication and information pertaining to the employer or members of the household shall be treated as privileged and confidential and shall not be publicly disclosed by the domestic worker during and after employment. Such privileged information shall be inadmissible in evidence except when the suit involves the employer or any member of the house in a crime against persons, property, personal liberty, security, and chastity. Agrarian Relations, raison d'etre. Agrarian reform was enacted primarily because of the realization that there is an urgent need to alleviate the lives of the vast number of poor farmers in our country. Tenancy relationship. The elements to constitute a tenancy relationship are the following. The parties are the landowner, the tenant, or agricultural lessee. The subject matter of the relationship is agricultural land. There is consent between the parties to the relationship. The purpose of the relationship is to bring about agricultural production. There is personal cultivation on the part of the tenant or agricultural lessee, and the harvest is shared between the landowner and the tenant or agricultural lessee. Constitution, just distribution. The 1987 Constitution mandates the just distribution of all agricultural lands subject to the limits prescribed by Congress. Under Article 2, Section 21 of the Constitution, the state shall promote comprehensive rural development and agrarian reform. Article 13, Section 4 provides that an agrarian reform program shall be carried out in the country. Section 4, the state shall by law undertake an agrarian reform program founded on the rights of farmers and regular farm workers who are landless to own directly or collectively the lands they till, or in the case of their farm workers, to receive a just share of the fruits thereof. To this end, the state shall encourage and undertake the just distribution of all agricultural lands, subject to such priorities and reasonable retention limits as the Congress may prescribe, taking into account ecological, developmental, or equity considerations, and subject to the payment of just compensation. In determining retention limits, the state shall respect the right of small landowners. The state shall further provide incentives for voluntary land sharing. A farmland or agricultural worker is any agricultural wage, salary, or piece of worker, but is not limited to a farm worker of a particular farm employer, unless this code explicitly states otherwise, and any individual whose work has ceased as a consequence of or in connection with a current agrarian dispute or an unfair labor practice, and who has not obtained a substantially equivalent and regular employment. Universal health care policy. It is the policy of the state to protect and promote the right to health of all Filipinos and instill health consciousness among them. Towards this end, the state shall adopt an integrated and comprehensive approach to ensure that all Filipinos are health literate, provided with healthy living conditions, and protected from hazards and risks that could affect their health care model that provides all Filipinos access to a comprehensive set of quality and cost-effective, promotive, preventive, curative, rehabilitative, and palliative health services without causing financial hardship, and prioritizes the needs of the population who cannot afford such services. C. A framework that fosters a whole-of system, whole-of government, and whole-of society approach in the development, implementation, monitoring, and evaluation of health policies, programs, and plans. And D. A people-oriented approach for the delivery of health services and is centered on people's needs and well-being and cognizant of the differences in culture, values, and beliefs. Coverage. Every Filipino citizen shall be automatically included into the NHIP, hereinafter referred to as the program. Every Filipino shall be granted immediate eligibility and access to preventive, promotive, curative, rehabilitative, and palliative care for medical, dental, mental, and emergency health services delivered either as population-based or individual-based health services, provided that the goods and services to be included shall be determined through a fair and transparent HTA process. B. Within 2 years from the effectivity of this Act, PhilHealth shall implement a comprehensive outpatient benefit, including outpatient drug benefit and emergency medical services, in accordance with the recommendation of the Health Technology Assessment Council created under Section 34 hereof. The DOH and the local government units (LGUs) shall endeavor to provide a healthcare delivery system that will afford every Filipino a primary care provider that would act as the navigator, coordinator, and initial and continuing point of contact in the healthcare delivery system, provided that except in emergency or serious cases and when proximity is concerned, access to higher levels of care shall be coordinated by the primary care provider, and every Filipino shall register with a public or private primary care provider of choice. The DOH shall promulgate the guidelines on the licensing of primary care providers and the registration of every Filipino to a primary care provider. National Health Insurance Program. Every member shall be granted immediate eligibility for health benefit package under the program, provided that PhilHealth identification card shall not be required in the availment of any health service, provided further that no co-payments shall be charged for services rendered in basic or ward accommodation, provided further that co-payments and co-insurance for amenities in public hospitals shall be regulated by the DOH and PhilHealth, provided finally that the current PhilHealth package for members shall not be reduced. PhilHealth shall provide additional program benefits for direct contributors where applicable, provided that failure to pay premiums shall not prevent the enjoyment of any program benefits, provided further that employers and self-employed direct contributors shall be required to pay all missed contributions with an interest compounded monthly of at least 3% for employers and not exceeding 1.5% for self-earning professional practitioners and migrant workers. Jurisdiction and remedies. Article 224 of the Labor Code provides that the labor arbiter is in his or her original jurisdiction, and the National Labor Relations Commission in its appellate jurisdiction may determine issues involving claims arising from employer-employee relations. Jurisdiction of the labor arbiter as distinguished by regional director. The Labor Code vests the Voluntary Arbitrator original and exclusive jurisdiction to hear and decide all unresolved grievances arising from the interpretation or implementation of the collective bargaining agreement and those arising from the interpretation of enforcement of company personnel policies. Since Article 262 of the Labor Code expressly provides that the award or decision of the voluntary arbitrator shall be final and executory after 10 calendar days from receipt of arbitrator's decision to the Court of Appeals must be filed within 10 days. Requirements to perfect appeal to National Labor Relations Commission. The appeal shall be filed within the reglementary period provided in Section 1 of this rule. 2. Verified by the appellant himself herself in accordance with Section 4, Rule 7 of the Rules of Court as amended. Number 3. In the form of memorandum of appeal, which shall state the grounds relied upon and the arguments in support thereof, the relief prayed for, and with the statement of the date the appellant received the appeal decision, award, or order. Number 4. In 3. Illegibly typewritten or printed copies, and 5th. Accompanied by 1. Proof of payment of the required appeal fee and legal research fee. 2. Posting of a cash or surety bond as provided in Section 6 of this rule, and 3. Proof of service upon the other parties. B. A mere notice of appeal without complying with the requisites aforestated shall not stop the running of the period for perfecting an appeal. C. The appellee may file the Regional Arbitration Branch of Regional Office where the appeal was filed his or her answer or reply to appellant's memorandum of appeal not later than 10 calendar days from receipt thereof. Failure on the part of the appellee who was properly furnished the copy of the appeal to file his or her answer or reply within the said period may be construed as a waiver on his or her part to file the same. D. Subject to the provisions of Article 218 or 225 of the Labor Code as amended once the appeal is perfected in accordance with these rules, the Commission shall limit itself to reviewing and deciding only the specific issues that were elevated on appeal. Reinstatement and or execution pending appeal. In case the decision includes an order of reinstatement and the employer disobeys the directive ordered under the second paragraph of Section 19 of Rule 7 or refuses to reinstate the dismissed employee, the labor arbiter shall immediately issue writ of execution even pending appeal, directing the employer to immediately reinstate the dismissed employee either physically or in the payroll and to pay the accrued salaries as a consequence of such non-reinstatement in the amount specified in the decision. The labor arbiter shall motu proprio issue a corresponding writ to satisfy the reinstatement wages as they accrue until actual reinstatement or reversal of the order of reinstatement and Bank Resolution number 11-12 series of 2012. The sheriff shall serve the writ of execution upon the employer or any other person required by law to obey the same. If he or she disobeys the writ, such employer or person may be cited for contempt in accordance with Rule 9. National Labor Relations Commission. Article 224 of the Labor Code provides that the labor arbiter in his or her original jurisdiction and the National Labor Relations Commission in its appellate jurisdiction may determine issues involving claims arising from employer-employee relations. Rule 6, Section 4D of the revised Rules of Procedure of the National Labor Relations Commission categorically states that deciding an appeal, the NLRC shall limit itself to the specific issues elevated on appeal. The decision of the National Labor Relations Commission becomes final and executory after the lapse of 10 calendar days from receipt thereof by the parties. Under the National Internal Revenue Code, a resident citizen who is engaged in the practice of a profession within the Philippines is obligated to file and duplicate an income tax return on his income from all sources regardless of the amount of its gross income under Section 51B of the National Internal Revenue Code (NIRC). The return should be filed with an authorized agent, bank, revenue district officer, collection agent, or duty authorized treasurer of the city or municipality in which such person has his legal residence or his principal place of business in the Philippines. Court of Appeals. In exercising the expanded judicial review over labor cases, the Court of Appeals can grant the petition if it finds that the National Labor Relations Commission committed grave abuse of discretion by capriciously, whimsically, or arbitrarily disregarding evidence which is material or decisive of the controversy, which necessarily includes looking into the evidence presented by the parties. Supreme Court. Time and again, we have held that the Supreme Court has the power to relax or suspend the rules or to accept a case from their operation when compelling reasons so warrant or when the purpose of justice requires it, and when what constitutes as good and sufficient cause that will merit suspension of the rules is discretionary upon the Court. Bureau of Labor Relations. The decision of the Bureau of Labor Relations in cases brought before it on appeal from the regional director are final and executory. Hence, the remedy of the aggrieved party is to seasonably avail of the special civil action certiorari under Rule 65 of the Rules of Court. National Conciliation and Mediation Board. NCMB. The NCMB as a staff and line officer has the following functions: formulate policies, programs, standards, procedures, manuals of operations, and guidelines pertaining to effective mediation and conciliation of all labor dispute. Number 2, perform preventive mediation and conciliation functions. Number 3, coordinate and maintain linkages with other sectors of institutions and other government authorities concerned with matters relative to the prevention and settlement of labor disputes. 4, formulates policies, plans, programs, standards, procedures, manuals of operations, and guidelines pertaining to the promotion of cooperative and non-adversarial schemes, grievance handling, voluntary arbitration, and other voluntary modes of dispute settlement. 5th, administer the voluntary arbitration program, maintain, update a list of voluntary arbitrators, compile arbitration awards and decisions. 6, provide counseling and preventive mediation assistance, particularly in the administration of collective agreements. 7, monitor and exercise technical supervision over the board's programs being implemented in the regional offices. And 8, perform such other functions as may be provided by law or assigned by the Secretary. Conciliation as distinguished from mediation. Conciliation is conceived as a mild form of intervention by a neutral third party. The conciliator, mediator, relying on his persuasive expertise, who takes an active role in assisting parties by trying to help disputants, talking, facilitating other procedural niceties, carrying messages back and forth between the parties, and generally being a good fellow who tries to keep things calm and forward-looking in a tense situation. Mediation is a mild intervention by a neutral third party, the conciliation mediator, whereby he starts advising the parties of offering solutions or alternatives to the problems with the end in view of assisting them towards voluntarily reaching their own mutually acceptable settlement of the dispute. Preventive mediation. Except for the fact that the union's notice of strike was treated as a preventive mediation at the instances of NCMB, or National Conciliation and Mediation Board, it should be noted that the union complied with all the requirements for a valid strike. It observed the cooling off periods required and submitted the necessary strike vote if ever there is any ground to discipline the union officers for non-compliance with the law. It would be based on the non-filing of the strike notice, which non-filing was a consequence of the NCMB's efforts to create the appropriate atmosphere to resolve the dispute by treating the notice of strike as a preventive mediation case. Otherwise put, the strike would have been legal in all aspects had not the NCMB, National Conciliation Mediation Board, in its good faith effort to settle the dispute, treated the notice of strike as a case for preventive mediation under those circumstances, and in the interest of industrial peace and the promotion of the concept of preventive mediation, the parties are directed to desist from committing any retaliatory act as a result of the work stoppage. The union, however, is hereby warned that in the future this office will not tolerate such conduct and will apply the force of the law. The Minister of Labor is not precluded from assuming jurisdiction over a labor dispute in a vital industry, even if there is no notice of strike or formal complaint. Department of Labor and Employment. DOLE. Secretary. Under Article 128 of the Labor Code as amended by Republic Act No. 7730, the Department of Labor and Employment, DOLE, Secretary and her representatives, the regional directors, have jurisdiction over labor standards violations based on findings made in the course of inspection of an employer's premises, which jurisdiction is not affected by the amount of claim involved. As Republic Act No. 7730 had effectively removed the jurisdictional limitations found in Article 129 and 217 of the Labor Code insofar as the inspection cases pursuant to the visitorial and enforcement powers of the DOLE Secretary are concerned. Jurisdiction or authority to try a certain case is conferred by law and not by the interested parties, much less by one of them, and should be exercised precisely by the person in authority or body in whose hands it has been placed by the law. Visitorial enforcement powers. Article 274. Visitorial power. The Secretary of Labor and Employment or his duly authorized representative is hereby empowered to inquire into financial activities of legitimate labor organizations upon the filing of a complaint under oath and duly supported by the written consent of at least 20% of the total membership of the labor organization concerned, and to examine their books of accounts and other records to determine compliance or non-compliance with the law and to prosecute any violations of the law and the Union Constitution and bylaws, provided that such inquiry or examination shall not be conducted during the 60 days freedom period nor within 30 days immediately preceding the date of election of union officials. Voluntary arbitrator jurisdiction. Voluntary arbitration really takes precedence over other dispute settlement devices. Such primacy of voluntary arbitration is mandated by no less than the Philippine Constitution and is ingrained as a policy objective of our labor relations law. The reinstatement order by the voluntary arbitrator should have the same authority, force, and effect as that of the reinstatement order by the labor arbiter, not only to encourage parties to settle their disputes through this mode, but also, and more importantly, to enforce the constitutional mandate to protect labor, to provide security of tenure, and to enhance social justice. Jurisdiction of voluntary arbitrator and panel of voluntary arbitrators. The voluntary arbitrator or panel of voluntary arbitrators shall have original exclusive jurisdiction to hear and decide all unresolved grievances arising from the interpretation or implementation of the collective bargaining agreement and those arising from the interpretation or enforcement of company personnel policies referred to in the immediately preceding article. Accordingly, violations of a collective bargaining agreement, except those which are gross in character, shall no longer be treated as unfair labor practice and shall be resolved as grievances under the collective bargaining agreement. For purposes of this article, gross violations of a collective bargaining agreement shall mean flagrant and or malicious refusal to comply with the economic provisions of such agreement. Remedies. A decision or award of a voluntary arbitrator is appealable to the Court of Appeals via petition for review under Rule 33. Prescription of actions. Money claims. Article 290 of the Labor Code provides that unfair labor practices prescribed within 1 year from actual such ULP, otherwise they shall be forever barred. Article 291 of the same code provides that money claims arising from employer-employee relations prescribed within 3 years from the time the cause of action accrued, otherwise they shall be forever barred. All money claims arising from employer-employee relations accruing during the effectivity of this code shall be filed within 3 years from the time the cause of action accrued, otherwise they shall be forever barred. Money claims and judgments against the government must be filed with the Commission on Audit. Illegal dismissal. An employee who is unjustly dismissed from work shall be entitled to reinstatement without loss or loss of seniority, rights, and other privileges, and to his full back wages inclusive of allowances, and to his order benefits or their monetary equivalent computed from the time of compensation was withheld from him up to the time of actual reinstatement. In illegal dismissal cases, the fundamental rule is that when an employer interposes the defense of resignation, the burden to prove that the employee indeed voluntarily resigned necessarily rests upon the employer. Unfair labor practice acts considered as unfair labor practice relate to the worker's right to self-organization and to the observance of collective bargaining agreement. Article 290 of the Labor Code provides that unfair labor practices prescribed within 1 year from actual such ULP, otherwise they shall be forever barred. Article 291 of the same code provides that money claims arising from employer-employee relations prescribed within 3 years from the time the cause of action accrued, otherwise they shall be forever barred. Labor-only contracting is considered as a form of ULP when unfair labor practice, when the same is devised by the employer to interfere with, restrain, or coerce employees in the exercise of their rights to self-organization. In Great Pacific Employees Union versus Great Pacific Life Assurance Corporation, the court observed that there should be no dispute that all the prohibited acts constituting unfair labor practice in essence relate to the worker's right to self-organization. Thus, an employer may be held liable under this provision if his conduct affects in whatever manner the right of an employee to self-organize. Offenses under the labor code. The law, in protecting the rights of the employees, authorizes neither oppression nor self-destruction of the employer. There may be cases where the circumstances warrant favoring labor over the interests of management, but never should the scale be so tilted as to result in an injustice to the employer. As a general rule, a medically repatriated seafarer is required to submit himself to a post-employment medical examination by the company's designated physicians within 3 working days upon his return. The purpose of the rule is to allow the employer's doctors a reasonable opportunity to assess the seafarer's medical condition in order to determine whether his illness is work-related or not. Illegal recruitment. Under Section 7B of the Republic Act No. 8042, the penalty of life imprisonment and a fine of not less than 500,000 pesos nor more than 1 million pesos shall be imposed if illegal recruitment constitutes economic sabotage. We point out that conviction under the Labor Code for illegal recruitment does not preclude punishment under the revised penal code for the crime of estafa. We are convinced that the prosecution proved beyond reasonable doubt that the defendant violated Article 3152A of the revised penal code as amended, which provides that estafa is committed by any person who defrauds another by using a fictitious name or by falsely pretending to possess power, influence, qualifications, property, credit, agency, business by imaginary transactions or similar forms of deceit executed prior to or simultaneous with the fraud. That ends labor law and social legislation. Verba Juris by Review Notes, Volume 1. Next topic is civil law.